Okay, they're slowly entering the Zoom room. So welcome everyone. My name is Veronica Lopez with Pace Business. Thank you all for joining today's webinar. Today's guest speaker is from Tzedek Small Business Essentials. It's the small, uh, I'm sorry, it's a webinar series provided by Tzedek Legal Services Small Business Development Program. Um, and today's topic is going to be contracts for small businesses. This has been a four-part series. I know, thank you, all of you have been joining us since March. This is the fourth of the four parts. So thank you, everyone. There are going to be people joining the Zoom room as we go ahead and start. For the interest of time and the topic, we're just going to go ahead and start. We are going to do the introduction for PACE. So that'll give people time to enter the Zoom room. As always, I like to know who's in the Zoom room, mainly not your specific name, but the type of business, maybe your business name, your industry would really help in case there are any specific questions in any specific industry. It gives us time to kind of steer it in that type of industry or try to address that type of industry. So with that, again, my name is Veronica Lopez. I'm a business counselor manager here at Pace Business. I oversee the City of Los Angeles BusinessSource Center for the Pico-Union Westlake region. Before we begin, just want to do some housekeeping. So everyone's listening mode. There will be an opportunity at the very end if anyone would like to raise their hand if they have any specific questions. But all questions during today's presentation should be entered into the chat box. Preferably, you do have a Q&A option, but we prefer the chat box. Today's webinar is being recorded. It will be available in the e-library. It will be definitely sent out to all of today's attendees, including the PowerPoint presentation, the slides. We kindly ask at the end of the webinar, there's a pop-up screen. It's a survey. If you can fill that out to give us feedback and also to help guide next year's, for us, the fiscal year is from July to June. It'll help us guide our programming for the following year. Okay, so PACE Business. So PACE offers one-on-one consultation, an entrepreneurial training program. That's a very intense training. It's a 25-hour course. We also ongoing business courses online and in person, like the one you're attending today. We offer small business financing. PACE is Community Development Financial Institution, a CDFI. So we have a pot of money. I like to think we recycle it back into the community, and the amounts is between 500 to 350,000. We also partner with other CDFIs to help you find financing for your small business. As part of our Worksource Center, we help hire employees and provide also workforce assistance to employers. One that I would like to highlight is on-the-job training, where they help to pay an employee's salary for the first 6 months. It's half of the salary. So it's for on-the-job training, and it may be extended for a longer term. Okay. Please note our upcoming webinars. So we have a series, I think this is the second part. Meet Our Procurement Experts. It's also a four-part series. It's happening June 25th. And then the next digital marketing, as many of you might be participating in that. That's been going on since, I think, last year until August of this year. So digital marketing for women-owned businesses. That happens July 17th. You can go ahead and scan the QR code. If you're already just listed on our e-newsletter, you should be receiving that information already. Oh, so for today's topic, we have been blessed to be able to work with Marco R. Castaños. He's staff attorney with Tzedek Legal Services, their small business development program. Just a little bit more about Marco before we get started. So through his work at SBD, Marco delivers pro bono legal services and know your rights presentations to small business owners and community members in Los Angeles County. So with that, I'm going to pass the presentation over to Marco. Thank you, Marco, for joining us.
Thank you so much, Veronica. Let me go ahead and share my screen. Great. So we'll just about get started. Thank you everyone for joining. Exciting that you're at the end of your uh, 4-week program. So congratulations and kudos to you for making it through all the way to the end if you have been. And thank you so much to Pace for hosting us on for this presentation. Some of you might recall I was speaking to you just a few weeks ago. And I'm here again today to talk about another legal topic on contracts for small businesses. Uh, we've talked about all of this before. I don't want to spend too much time repeating the information regarding Tzedek and SBD, but I do want y'all to know that we are one of the oldest legal aid organizations here in LA County, having been here for over 50 years. We're able to provide legal services to people to our clients and our client community, regardless of race, religion, ethnicity, or immigration status. Um, in SBD, in our small business development program, we're just a small part of the overarching umbrella that is Tzedek. Tzedek offers a lot of work in areas including immigration law, which is super important right now, right? And public benefits, litigation and appeals, and administrative processes, um, employment law, housing law, and our small business program. Our small business program is equipped to support on transactional matters. So that means everything that's outside of litigation. We don't file lawsuits, we don't defend lawsuits. Um, and but we do help with things such as contracts, negotiating leases, negotiating certain disputes, and talking about questions regarding legal compliance in areas of intellectual property, employment law, insurance, etc. We offer presentations such as this one in concert with our community partners, and we also offer direct client representation. For our direct client representation, our services are limited to people who are geographically and financially eligible. Financial eligibility verification requires having a conversation at the intake stage regarding the household's income and the business's profits and sales. Our services are limited to LA County, only to for-profit businesses, um, and our services can be provided in a wide array of different languages. And we are equipped to provide accommodations to people with different language abilities or different accessibility abilities as well. I'm sure Veronica, I'm glad because Veronica's been working with you all for so long, and I'm sure she has shared our resources at Tzedek multiple times. Here it is again. The first step to getting in touch with us is our application for assistance. It's right here. Please stay in touch with PACE because our intake procedures are being updated as we speak, and we're going to have a new website dropping very soon with easier, more direct, efficient access to our resources and recordings that we have available online. Although I understand, you know, great work. Thank you to Pace for facilitating and maintaining a resource library of your own. So without further ado, I do want to get started on the conversation. Before we do, I do need to read this out loud. The following information is intended to assist in spotting legal issues relevant to small businesses in California. Many factors must be considered in determining which actions and decisions would be most appropriate for any specific situation. This presentation only discusses some of the more critical factors. It is not intended to substitute for legal advice. Um, After discussing it thoroughly with an attorney, you should decide which course of action is best after discussing it thoroughly with your own attorney. Thank you, Veronica, for putting those in the chat. These are the sections that we're going to discuss today. What makes a contract, which contracts must be in writing, performance, breach and termination, and certain practical considerations. There's a lot of information here. This is a very dense presentation. We do that on purpose so that when we make it available to you, you have access to this information. And you can rely on it as part of your your own personal resource library for some of these legal topics, including this one specifically. Presentation is designed for business owners and entrepreneurs, anyone really who is drafting, laying out, negotiating, envisioning commercial contracts. That means contracts with your clients, contracts with your providers, contracts with any other third party. That could be, perhaps a leaseholder or a property owner, or a licensee or a licensor. Uh, but any commercial transaction that you can envision occurring during the course of your business, because at the end of the day, that's what we're doing here, right? We're moving resources around, we're moving capital around, and we're finding a way to help grow our business by engaging commercially with other actors. There are responsible and less responsible ways of doing this. And you're never going to be protected 100% because there's always that eventuality that can occur, that can happen, that would be novel, that would be new, that would complicate things and make your particular dispute unique. But for the 90 to 99% of other situations, let's hope, we want you to be as prepared as possible. So what does it mean to prepare yourself? That means inform yourself and be equipped to handle as many of the eventualities as you're able to in that point. I don't want this to be a presentation that's like, oh, this is too complicated, I'm never going to do this. But I want you to understand that this works in concert with your business plan. It works together with your business plan, where when I reach this stage in my business plan, maybe now I'm more equipped to expand my protections further. When I reach this next part of my business plan, well, maybe I can expand the protections even further because I'm dealing with more risk, and more reward. And that's the type of situation where I want to be even more prepared. These are issues that large companies visit and revisit multiple times each year to keep these things updated. And it's something to tie into your business plan, as something that's growing, moving, constantly changing. So what is a contract? Essentially, we're talking about an agreement between two or more parties, and it requires certain formalities. It's an offer to perform something, acceptance of that offer, and an exchange, what's called consideration, an exchange that happens between the parties in order to verify that that performance is going to happen or will happen. Those are the elements of a valid contract. We'll talk about exceptions in a moment, but there are verbal agreements that have that. Um, if the verbal agreement means like in exchange for, for that offer, here you go, you're going to go get started, that's a valid contract. Um, and sometimes a verbal contract might be backed up by a writing, right? A signed writing. And that signed writing might say, this is it, everything is here. These are the terms of the contract. Well, that becomes a written contract. But sometimes it's not backed up by a single signed writing that integrates all the terms. Sometimes it might be more than one writing, a string of text messages, a string of emails that lay out the terms. And that's where things start to get complicated, because which text messages are included in the contract and which ones aren't. If you want to prepare yourself as much as possible, even at early stages of your business, keep in mind, I'm going to say in writing as much as possible, because that's how you're going to protect yourself. That's how you're going to prepare yourself. And that writing should include certain basics, in order for you to really, really give life to this agreement, to this negotiated agreement between the parties. First of all, identify who are the parties. Are they individuals? If so, where do they reside, right? Celor Marco Castaños, resident of California, an individual residing in California. Or is the party A separate business entity, right? We talked about this last time. What does it mean to have a separate business entity, LLC, corporation, etc.? Is this an agreement that's being entered into by and between separate business entities? So it's going to say the parties are, ABC LLC, a California limited liability company. ABC LLC, a California limited liability company by its agent, Marco Castaños, managing partner of ABC LLC. That last example is a way to identify, yes, it was a business that entered into the agreement, but who was it represented by? In that example, the business is still the one that is holding themselves out as um, the party to the contract that's going to be bound by its terms. But who negotiated the contract in fact? Who is signing the agreement in fact? It's going to be Marco. Marco as managing partner of ABC LLC. As long as my signature says Marco da, 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 manager of ABC LLC, well then it's still the separate business entity that's signing. You also want to have definitions of terms that you're going to be using in the contract. If it's for property, I properly identify that property. Give a definition in the beginning that states when I use the term property, it refers to 20 boxes of supplies that are being sold, right? When we're talking about real property or the subject property is defined by, let's say, 3250 Wilshire Boulevard, Los Angeles, California, right? That's where Tzedek's office is, for as an example. And then introductory material, we call those preamble or the preamble or the terms at the beginning that say, like considering that X party and Y party want to enter into an agreement for this. Considering that they want this completed by X date, right? Those are examples of introductory terms or part of the preamble that is non-binding. It's not a part of the contract, but it is a section that gives life, gives meaning to the terms of the contract, so that if this dispute ultimately ends up being resolved in court, there's additional evidence on the body of the agreement that states what the purpose was behind it, what the relationship was behind the parties. And those are basic examples of terms that could color in a valid contract and make it so that you're able to enter into agreements with third parties around you, knowing what to put on the paper as you get started. Specifically, there are certain contracts that must be in writing. Generally, contracts that require more than 1 year to perform. The promise to pay the debt of another. Sales of goods valued over $500. Or transfers of real estate or leases that for more than 1 year. That must be in writing, and if it's not in writing, it's not enforceable. Second, after we've, cleared up both the parties, what did we say? We said the parties, the definitions, and the preamble. Well, then we want to define we want to lay out what the contract is for. What does performance mean? What is the scope of performance? What are any restrictions of performance? Is there a schedule that really details what performance is going to look like if it's going to take a month or more to perform? And when it comes down to conveying the goods, if it's for goods, what does performance mean on the front end or on the back end? These are questions that I want you to ask yourself while you're drafting a contract with a party so that you are preparing for eventualities. And even if your first commercial contract is super basic and doesn't include every eventuality, It's a question you can keep asking yourself, especially based on information and experience gained over time to further expand your contract. That's also why it's important to your draft, your template contract. And that's why it's really important to work with organizations like PACE that can connect you to business mentors in your field that can prepare you and inform you of what potential eventualities have occurred in your industry in the past. Obviously, if we have performance, well, actually, no. Right there, we'll pause for 2 to 3 minutes to gather any questions. So far, we've discussed what makes a contract enforceable. We've discussed key terms. We've discussed contracts in writing and performance.
Marco, we currently do not have any questions.
Well, I'm still gonna hold it open for a minute or two. If anybody is able to think up a question up to this point, I'm happy to answer it before we move on.
Okay.
Thank you, Veronica. Okay, let's keep going. If we have performance, then we're gonna have breach. What does it mean to break the contract, right? Because that's why we have the contract in the first place. We want to be able to protect ourselves from somebody, either yourself or the other party, or a third party if they're also a party to the contract, not following through on their obligations under the agreement. Um, when one party is unable to fulfill their end of a bargain, that's known as breaching. A breach can be non-performance. Oh, I simply didn't do or didn't provide the good or service that was contracted for. But we can also have uh, breaches that rely on partial performance or substantial performance, right? So if it's for the sale of goods, if the definition is or the language is in the written contract, and if the goods are not perfectly as described, well, that's a breach. And if it's a service contract, a contract for the services of another, well, then it can be breached by a minor or substantial non-performance as defined under the agreement. What does it mean to what is a minor versus a substantial non-performance? We run into this in situations like event vendors, right? Like caterers for a wedding or for events such as that. Um, in the service contract that we generate, it's contemplated what does it mean for the vendor to be unable to perform based on other risks or factors, but they are still able to provide some type of performance that makes it so it's still okay, or that type of breach isn't such a big deal. So when we're talking about sales of goods, if there's non-conforming goods that come up, then the buyer or the person who's going to receive gets to decide what they're going to do. Are they going to reject the goods outright and say that it's a breach? Are they going to keep some of the goods and then calculate the damages that they still suffered? And does the contract give the seller the right to have a second chance to provide the right goods without suffering any exposure to of damages to the other party? But service contracts, right? We talked about minor versus substantial breach, a material versus a minor breach. What does the non-breaching party want to do? And how does the non-breaching party want to treat the breach? Was this a big deal? Was this not a big deal? Are we able to modify this on the fly? Are we going to just accept what's happening and then sue for damages after the fact? We can't define for you what a material breach might be. That's because it's on a case by case basis. Um, and really depends on what the terms of what performance under the contract might mean. This is a slide that I'm not going to delve into, but I want it to be available to you as far as resources. This slide delves deeper into defining key terms and steps that relate to breach and termination and remedies. So, what does it mean when it becomes obvious from very early on that a party is not going to be able to perform? Um, at what point and through what methods do parties agree to modify the contract so that, it's able to keep rolling based on a change in circumstances? But really what we're talking about here is if a party breached the contract, terminated the agreement, what does it mean to sue for or recover damages? How do we correct, how do we remedy the injury that was suffered by the breach in the agreement, right? Because that's always going to happen. The parties agreed to something, they mapped out what performance was going to look like, they were depending on that performance, they were counting on it. But ultimately, one party failed to follow through and the other party suffered damages. Then you envision yourself as the non-breaching party, as the suffering party. You envision yourself, okay, what does it mean to file a lawsuit? What does it mean to take the steps necessary to eventually file a lawsuit based on that breach? And lawsuit means I'm seeking out a legal remedy. And a legal remedy is damages. Damages are monetary damages, specific performance or injunctive relief, rescission, uh, consequential damages, punitive damages, and liquidated damages. These are things that you can obtain via a lawsuit. Now, what do those mean? Monetary damages. You suffered a loss. You're able to properly account for the loss using, accounting terms and methodologies, and you sue for those damages. Um, those are the damages that you suffered, and you make a claim for those, uh, monetary wise. In addition, are consequential damages, which are secondary and tertiary damages that you experienced based on the breach, right? Let's say you were counting on performance of this contract so that you could then follow through on another contract, but based on a breach of the first contract, you weren't able to follow through on the second contract. So then you're exposed. Those are consequential damages. Are you able to hold the original party accountable for making you suffer those secondary, those consequential losses? Punitive damages. Was the breaching party willful? Did they have intent? Was there intent behind this breach? Or was it reckless? Was there negligence in their intent such that it's substantial enough for it to rise to malice in their mindset, such that they need to be punished via punitive damages? And liquidated damages. Liquidated damages are specific damages outlined in the contract, right? The contract says if there's a breach, The non-breaching party gets to recover $500, boom, from the very beginning. Aside from compensatory damages, aside from consequential damages, aside from punitive damages, there is a liquidated damages term. And there can also be statutory damages, where there's a clearly defined statute on point that says that if a party does this, they are liable for X amount of money. Now, they might be liable to the state for doing so, or they might be liable to the non-breaching party for doing so. And then finally, attorney's fees clause. And this is what attorneys base their living off of, right? Private attorneys, attorney's fees clause. Under the contract, uh, the prevailing party, whether it's the non-breaching party or the breaching party, um, and I hesitate to call it that because if a breaching party prevails, it means that they might have had some reason to breach in the first place. Um, but prevailing party gets to recover their attorney's fees, and costs, and that means that the other party has to pay for those. And you can consider in your contract to have caps or limits to what those attorney's fees are, so that you're not finding yourself on the hook for um, limitless attorney's fees. Veronica, is my camera being buggy? Can you still hear me?
I can hear you, but sometimes your video freezes. But this is good, I think, if you just turn off video.
Got it. And I didn't turn it off. It did so automatically.
Oh, okay.
Oh, now it's saying that my computer can't even detect the camera.
Oh, okay, we can just go on.
For sure. Thank you. Sorry about that, folks, but we make do. Now we get to some meaty considerations regarding breach and termination. People like to hear about force majeure, events beyond the party's control, acts of God. Um, and what does that mean? We've had potential examples in the pandemic. Uh, if you're in downtown and your business had to close, uh, what does that mean in relation to your contract? And I want to be clear about what these mean, right? Because we ran into this question so often during the pandemic, and the way things seem right now, we'll probably keep running into it, for natural causes and otherwise, as far as business closures, etc., or negative impacts to the business. Breach or termination based on force majeure means that the parties are able to terminate the contract without there being consequences or penalties to the parties. Because traditionally, in an early termination or breach, there's consequences, right? We just talked about those. A party might be liable for damages, um, based on a lawsuit or any other kind of remedy as defined by the court. We didn't talk about acceleration clauses, but in contracts for extended terms of payment, it can be for like payment of a debt or paying a lease. Acceleration clause means if you miss a payment, then all the payments become due immediately. So even though your payment was only $200, but you owe a balance of $2,000, if there's an acceleration clause, it could mean that once you miss that first $200 payment, you're now liable immediately for all $2,000. That's how those work. So in a force majeure event, if you're a breaching party or a party that terminated early and you claim force majeure, that means that the contract, you're arguing for the contract to be dissolved without penalty. I want to be clear about that because in a contract for a commercial lease, that doesn't mean you get to stay. That means that you are no longer liable for rent, but it also means that you get to vacate without suffering additional exposure. Claiming force majeure doesn't mean you no longer have to pay, but you get to stay, because then those things don't line up. Because when you're saying that there's a force majeure that interferes with your ability to perform on the contract, that means that you're trying to dissolve the contract and free yourself from those terms. But dissolving the contract necessarily means vacating. So if you're in a commercial lease and you want to claim force majeure, then you need to be careful about what you mean there. Does that mean you don't need to pay rent for this month, but you want to be able to continue operating later on after the event passes? Well, you're still in the space, so you're still accruing rent. But if you no longer want to be liable for that rent payment, well, then necessarily you are saying that you would like to dissolve the contract, which means that you want to vacate and avoid any acceleration clause and avoid any fees or costs related to that immediate month. Okay? So that's how that term operates. The next few slides concern what are called practical considerations, but basically they are other key definitions, key terms that are relevant when negotiating a lease. What warranties are implied, what warranties must be expressed, and how to disclaim warranties. That's very minor details. There's like weeks of law school at a time devoted to this. But feel free to reference this slide in the future. But modification seems to be more relevant, more important. Give yourself room to modify the terms of a contract because things happen. And give yourself a procedure for modifying the terms that's convenient to you and that's convenient to the other party. That's just going to help you at the end, especially so that you're avoiding, for instance, verbal modifications that you don't have evidence of, and then give cause or cause to arise a dispute or a lawsuit. Next, we have assignment and delegation. These are super relevant, and I will go into them because they relate to exit strategies, and I want y'all to be informed of exit strategies under commercial agreements because things happen. Assignment means when you want to be able to step out of a contract and assign rights and obligations and benefits to another party. Just about every contract can do so. Gives the parties the right to assign their duties, obligations, and benefits and privileges. Contracts usually have terms that relate specifically to assignment and might limit the ability to assign from one to another. Assignment is convenient because it gives you a way to sell your interest in a contract. You're like, I'm not gonna be able to perform, but another party might be able to follow through on it. A third party, let me sell my interest to them, cash out, but have them and then have them now be the party to the contract. Um, Delegation is similar, but different, and there are certain instances where you cannot delegate a duty or an obligation under a contract if for instance you are part of that contract specifically for your skills. Okay. Terms to consider in your written agreement. These are just like terms that you might consider adding to the last page. What's called an integration clause, which states that what is on that piece of paper is the entire agreement. And you can't bring in outside evidence that modifies the terms. Severability clause, which means that even though one term ends up being unenforceable, the others still apply. Jurisdiction, where a lawsuit must be filed in case of a dispute. Transaction costs and how those will be divided between the parties. And the rights of third parties and third-party beneficiaries. So some closing notes. What I want to suggest to you is that you keep things in writing. You keep them simple. If you are negotiating with a corporate or a business entity, make sure you're talking to the decision maker. Make sure you're talking to somebody with authority to actually enter into such a contract. If you are negotiating with a commercial or business entity, again, identify those parties correctly. Who are they? Where are they domiciled? What type of entity are they? Include details, including a preamble or definitions. Be specific about payment obligations and terms. Contemplate what it means to terminate the contract. Contemplate how the parties want to resolve disputes. Contemplate where you want to resolve these disputes, as in LA County or elsewhere. And duties of confidentiality between the parties as per the contract, right? Are they allowed to, what terms, if any, are they allowed to share with other parties? And under what terms would they not be allowed to share certain information with other parties? Um, that's about it for me. I want y'all to be connected to this page, which I'm sure Veronica has, and it's also great because I understand that Pace keeps its own library. But finally, I'll just hold this here and make myself available for questions.
Okay. So Marco, thank you. And then we do have questions. I'll give you the first questions that came up. So in California, how enforceable are agreements done via email? That is, no signature on a contract.
So, what we have in an email, it's still a writing, right? And what this question really means is, Marco, can you guess the state of mind of a judge or jury in reviewing the details of a dispute between contracting parties? The answer to that is, first question that a judge is going to ask the parties, is there a signed writing? No, there's not. But there is a writing. It's a string of emails. The next question becomes, okay, who is the grieved party? And who is the breaching party, right? Who is bringing the lawsuit? Because there's different standards that define how those terms are going to be read. So the way I can answer this question is, there may be terms that end up being enforceable. there may be terms that end up being unenforceable or enforced differently from what the 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 filing party had hoped because of judicial standards of like, oh, okay, um, you drafted this email and you're also filing the claim. Well, we're gonna interpret it as it being against you because there's a presumption that because you drafted it, you wanted it to be to your benefit, so we're gonna have to make it unbiased in how we decide. Um, so if you don't have a signed writing, the answer then becomes, how do you make written correspondence as detailed as possible so that you still get your intent across? Because at the end of the day, if there's no signed writing, one of the factors that a decision maker is going to rely on, that's what enforceability means. Enforceability means getting a decision maker to agree with me. One of the factors that a decision maker is going to rely on is, what was the intent? What was the party's intent behind their being a party to this contract?
So Marco, I'm understanding, going back to your original slides, that there has to be all the parts of a contract then in an email. It just can't be like this agreement in this email. It's more of like if they're all the parts. Is that correct?
That's partly true, and
Okay.
it could be really helpful, right? But if it's a verbal agreement that is allowed to be a verbal agreement, and the filing party states in their complaint that offer, acceptance, and consideration were present verbally, then that would be enough. That would be enough to get the ball rolling.
Mm.
And then a judge might say, oh, let me see if I can back up your allegations based on the emails. And if the emails don't back that up, then it becomes another question. Through discovery, through your lawsuit, are you able to get the other party to admit that, yes, there was a conversation and the conversation had all those things? So it just becomes more and more burdensome to prove. It becomes more and more difficult to prove if the writing doesn't say that, right?
Yeah.
So if the emails have offer, acceptance, consideration, then boom, that's great. That's going to back it up. That's going to back up your allegations. But if the email doesn't have offer, acceptance, and consideration, are there other ways that you can prove that using other forms of evidence?
Solely, hopefully that answers your question. Um, if not, please, give us follow-up questions. But we have another question. Uh, so just to verify, as long as my name is signed representing the entity, then my company is liable, not me personally. Is that correct?
Okay. I'm gonna repeat this and I said it at the beginning. Um, this isn't counsel and advice. We're not establishing attorney-client relationships with anyone. I'm going to take your question and answer it generally. So I'm not going to tell you what to do or tell you if you're right or wrong, but I'm going to tell you what the legally appropriate method for doing so. So what I'm hearing in your question is, how do I make it so that the legal entity is party to the contract and not the individual business owner?
That's correct.
Um, Again, intent, right? So intent is going to color in the terms of an agreement. So in a preamble, in the whereas clause or considering clause, if you say, whereas the party such and such LLC and such other person would like to enter into this agreement, well then boom, we have more written evidence that shows that whom we wanted to be party was the LLC, not the owner. Now, the ways to do this in the body of the contract, where we are identifying the parties, well, then it would be, there's a couple of different ways of doing this. There's a couple of different options, but they all rest on properly identifying and naming the LLC in the body of the contract. So one of the earliest terms, it would actually be a definition, the definition that identifies the parties. It's going to say, let's use an example, a contract for services, a wedding event. Let's say a wedding photographer, but the wedding photographer is incorporated or organized as an LLC. Let's call it Photo LLC. Um, Photo LLC is gonna be the vendor. So it's gonna say vendor, or it's gonna say Photo LLC here and after, quote unquote, vendor. So anywhere vendor appears in the body of the contract, it's going to refer to Photo LLC. And it's actually going to say Photo LLC, a California limited liability company, here and after vendor. Well, then Photo LLC is the vendor that is party to the contract. Now, another term that we can include is ARCO, a California individual, as agent of vendor, quote unquote, or here and after, quote unquote, vendor's agent. And that might characterize what I'm doing for the contract, but it doesn't say that I'm a party to the contract. It's that I am representing the party to the contract as its agent. So that's what happens at the beginning, at the top part. And then at the bottom part, at the signature line, we've all seen signature lines, right? There's date, signature, name, and title. So then we would have first Photo LLC, and then a signature line, my personal signature, name, my name, Marco Castaños, and then title, agent for Photo LLC. Does that make sense?
It does make sense. So in the beginning, you're defining the terms and then you stick with those terms throughout the contract. But even though it's the LLC or the corporation, and the individual on behalf of the corporation can sign, it doesn't hold them liable.
Correct.
So, yeah, okay.
Correct. Right. And then so you still want it to be clear that the entity that's signing is Photo LLC, right?
Yes.
So you might even put date, type out Photo LLC, my signature, my name, my title, agent for Photo LLC. And the idea is multiple people could potentially sign for Photo LLC, right?
That's correct.
If it's big enough, it has vice presidents that can sign for it. It has a manager that can sign for it. It has a secretary that can sign for it, and things like that.
So based the way that you created that contract, anyone could have signed, not necessarily the owners technically, just a
Any authorized person.
authorized person. Sorry. Okay.
Any authorized person. And then authorized person is defined in the operating agreement for the LLC itself.
We do have one live, so Keisha's been waiting patiently. So Keisha, I will unmute you, allow you to speak. So you're going to be moved to panelist. Yeah, go ahead to start speaking when you are promoted.
Hi, everyone. Thank you for the presentation. I wanted to ask a very important question because I do not know this answer. I've been in a lot of accelerated programs and cohorts, and I'm doing collaboration and partnerships with people, but I don't have a contract. And also, I have a friend named April Stewart, and she's willing to put my chocolates into her concession stand at LAX airport, and I don't have a contract for her to sign. Do you have any classes or any training that I can come down and take so I can know how to go about in partnership and collaborations with people and have a contract to where I could cover myself and my product that I'm giving over to the people to sell?
Yeah, Thank you. Um,
Thank you.
so the first step is connecting with us,
Okay.
filling out an intake application so that we can work with you specifically to to generate that type of template agreement for your own portfolio. But
Okay.
that's definitely the type of work that we do.
Oh, good. So would that contract also go with the unsolicited proposal? If I want to solicit and maybe work in just one VA hospital and I do an unsolicited proposal, should I also have an agreement as well?
I can't answer that with this
Oh,
level of detail.
Yeah, Keisha,
Um,
it's very specific question. I think if you go to the application for assistance, the link, click on it and go ahead
okay.
and fill out the intake to you can schedule a
Now, I
meeting.
know I have already filled out your intake
Okay.
because I'm getting my trademark done through
okay.
the Tibet, but is there a separate one that I need to fill out for something different?
No, so if you're already connected with one of our advocates,
Yes.
then just check in with them. And the way that we handle things, especially if you're an existing client, we have to take them step by step, just based on capacity concerns, right? So
Yes.
if you're already working with us on something, don't be surprised if uh the reply is to, hey, let's wrap up this trademark matter as much as possible before we get moving on the next one.
Okay, so we have to wrap up one before you can help me with something else.
That's oftentimes the case.
Do you have a template maybe we can use for
We wouldn't be
contracting or
able to
agreement?
share, we wouldn't be able to share a
Okay.
template without
Okay.
without, agreeing to that service.
Okay, thank you.
Okay, thank you, Keisha. Now we have a question from the Q&A. Was anonymous. If there is an audio recording showing both parties agreed on the terms, is that a valid contract?
I mean, it depends on whether you had the consent of the other party to record them.
Okay. So, anonymous, if you want to add that piece, and then we'll move on to the next question. So we do have one person that provided a scenario, but I think it might be outside of the scope of today's webinar. Would you like me to read it, Marco? It's I think I'll go ahead and read it and then you can decide. If there is no contract, but there are emails that state the scope of the service and fees, and the client signs an invoice afterwards, can this service serve as evidence that the client has the responsibility to pay? What if the client argues that they did not fully understand the scope but signed the invoice anyway?
For sure. So, again, can't provide legal advice. And this is one where it's really specific situation. So I'm going to go back to, I mean, I think it's a lot of these questions have flirted or circled around similar questions, which is like, how do I prove this? Um, what do I use or what can I point to prove this? Um, and this is a great example of yeah, like there are several writings, including a signed writing, that demonstrate something, right? Especially if they signed an invoice, that demonstrates something. Um, so when it comes time to disputing this, I can't tell you what a judge is going to think, but I can tell you what a judge is going to look at. A judge is going to look at the signed writing, whether the signed writing has an integration clause that says this is the only agreement. And if the signed writing has an integration clause, well, then a judge is not going to look at emails. If the signed writing relates back to a email correspondence, right? If the invoice says, referencing emails from June 17 to June 20, 2025, where this was described, here is the invoice. Well, then, boom, like automatically your signed writing says that the emails were enforceable, that the emails are the details. And that gives a judge permission to look at the emails. If the invoice is silent, like it doesn't have an integration clause and it doesn't reference the emails, well, then now a judge is able to open the entire universe of other evidence to look at. Among those is going to be the emails. So the judge might use the emails not to be fully enforceable, but to illustrate, to provide evidence of what the terms may have been, but they're always going to compare it to the other side's defenses and any evidence the other side might have to support their defenses, right? Like if there's an email and you say the email is enforceable and the defense is I didn't understand it, and the defense has a text message where they sent you and they said, hey, I don't understand this. Well, then that's evidence that they didn't understand it. So it throws doubt. So like the idea is how far open does the universe become based on the signed writing? If the signed writing says this is it, well, then that's it. If the signed writing says look at those emails, well, then you look at those emails. But if the signed writing doesn't say anything and it's ambiguous or silent on certain terms, well, then the whole universe gets thrown open.
Thank you, Marco. So I know we're past time, and we had some people, actually, they had questions, but now they've left, but that's okay. Kind of worked out. So thank you, everyone, for joining us. And of course, a big round of applause for Marco Castaños with Tzedek for offering to provide us with education on business contracts. I know for businesses, this is a very big topic, especially creating the correct contract and being able to make sure, just like Keisha mentioned, like having the right contracts in place when you're just starting your business, just to make sure all parties understand and the terms of the partnership. So thank you very much, everyone, for joining us. And thank you again, Marco. And we look forward to seeing you again at another one of our webinars. And enjoy the rest of your afternoon. Thanks.
Thank you so much, Veronica. Sorry about the tech issues.
Oh, no worries. You've been great. Thank you.
Thank you.